G'day everyone, and welcome to the fifth and final video in what's been a huge week of material in our Legal Ethics and Trust Accounting course. This week, as you've certainly figured out by now, we're looking at ethics as they apply in courtroom advocacy. We've talked about the duty of formality in court, the duty of independence, the duty to make responsible use of the court's proceedings, and we've talked about the duties that each practitioner owes in relation to witnesses. In this final video, we're going to look specifically at the ethical rules that apply to advocates who are serving as criminal prosecutors. Their position is unique, and the ethical rules binding them are also unique. The first thing to understand is that there are three different types of prosecutors that you're likely to run into if you do some criminal law. The first type are police prosecutors. You're most likely to run into police prosecutors in magistrates' courts, where they usually have about 1 million matters to deal with each and every day. They do run trials at magistrates' court level too. Not all police prosecutors are lawyers. It's one of the limited situations in which a person can appear before the court without being admitted as a practitioner. However, don't let this fool you. Many of them are lawyers, and all of them, lawyers or not, have spent heaps and heaps of time in front of the court. The second type of prosecutors are full-time prosecutors employed by either the Queensland or the Commonwealth Director of Public Prosecutions. These are really the expert prosecutors. They're all legal practitioners. Many of them have been prosecutors for their entire career. Many of them, as they advance, complete the bar practice course and they're admitted as barristers. It's even possible for a prosecutor to become a Queen's Counsel as a result of their experience as a prosecutor. Finally, you'll sometimes come across barristers at the private bar who occasionally get briefed to undertake prosecutions. These are not full-time prosecutors, but they usually have extensive experience in the criminal law. Regardless of the type of prosecutor who's on the other side, they will all be bound by what are called the DPP Directors Guidelines for Queensland prosecutors, or the Commonwealth Prosecution Policy for Commonwealth prosecutors. These are public documents and copies of them will be provided with this week's materials. They set out the specific guidelines for how prosecutors are to undertake prosecutions. They're very detailed and go from very general views about which matters to prosecute to very specific decisions about how to handle different types of witness. It's important to understand that these are not rules of court. They're not binding on the court. You can't, for instance, raise an objection in court if a prosecutor is failing to abide by the policy. However, they do publicly set out the expectations that the government has of prosecutors. Those guidelines are then read alongside specific solicitors' conduct rules and barristers' rules that apply to prosecutors. The first thing to understand is that unlike most litigants, it is not the proper role of a prosecutor to seek to win. It is not the prosecutor's objective to secure a conviction. A prosecutor's role is to fully, fairly, and properly present the case against the defendant so that the judge and the jury can properly consider their verdict, and if there is a conviction, so that the offender can receive a just sentence. Solicitors' Conduct Rules 29.1 and 29.2 say a prosecutor must fairly assist the court to arrive at the truth, must seek impartially to have the whole of the relevant evidence placed intelligibly before the court, and must seek to assist the court with adequate submissions of law to enable the law properly to be applied to the facts, and a prosecutor must not press the prosecution's case for a conviction beyond the full and firm presentation of that case. Barristers' Rule 82 and 83 are in almost the same terms. Item 1 of the Prosecution Principles in Queensland says a prosecutor has the duty of ensuring that the prosecution case is presented properly and with fairness to the accused. The Commonwealth prosecution policy says, throughout a prosecution, the prosecutor must conduct himself or herself in a manner which will maintain, promote, and defend the interests of justice. In the final analysis, the prosecutor is not a servant of government or individuals. He or she is a servant of justice. The theme of being fair to the defendant runs through all this. And of course, the defendant is entitled to natural justice. Part of this means that the defendant is entitled to know, before trial, all of the evidence that the prosecution intends to bring at the trial, so they can prepare a defence against each of those disclosed matters. So we say that the prosecution has a duty of disclosure to the defence. Solicitors Conduct Rule 29.5 begins, a prosecutor must disclose to the opponent as soon as practicable all material, including the names of and means of finding prospective witnesses in connection with such material, available to the prosecutor or of which the prosecutor becomes aware, which could constitute evidence relevant to the guilt or innocence of the accused. Barrister's Rule 86 is in almost identical terms. Section 29 of the Queensland Prosecution Policy begins, the Crown has a duty to make full and early disclosure of the prosecution case to the defence. The Commonwealth has a specific disclosure policy, the introduction to which says, it is a long-standing tenet of the Australian criminal justice system that accused persons are entitled to know the case against them so that they can properly defend the charges they face. An accused is entitled to know the evidence that will be adduced in support of the charges and whether there is any other material that may be relevant to the defence of the charges, including material relating to the credibility or reliability of a prosecution witness. A failure to disclose may result in a miscarriage of justice. So, as a matter of ethics, there can never be surprise witnesses in a prosecution case. We do not prosecute people by ambushing them. Similarly, because prosecutors are required to put all of the evidence fairly before the court, this means the prosecution should make available all witnesses with material knowledge of the accusation, whether the prosecutor expects those witnesses to assist or to oppose the prosecution. I can't emphasise this enough. The role of the prosecutor is to put the whole case fairly before the court, not to selectively give the court just the material likely to support a conviction. Solicitors Conduct Rule 29.7 says a prosecutor must call, as part of the prosecution's case, all witnesses whose testimony is admissible and necessary for the presentation of all of the relevant circumstances and whose testimony provides reasonable grounds for the prosecutor to believe that it could provide admissible evidence relevant to any matter in issue. Barrister's Rule 88 contains the same words. Why though? Well, one reason we've already noted, the prosecutor's duty is to put the case fairly, not to go for the win. Second though, as most people know, an accused person is entitled to remain silent. The right to silence is sacrosanct. In a criminal trial, the accused person doesn't have to call any witnesses. They don't have to give any evidence. They can remain silent and challenge the prosecution to prove the charge against them. But the right to silence would be useless if the prosecution could just defeat it by selectively calling witnesses. There would be no right to silence if the prosecutor was essentially saying, look, we both know there's a witness here who can help you secure an acquittal, but I'm not calling them. You can call them if you like, but that'll mean foregoing your right to silence. Not cool. The right to silence is only helpful if the defendant knows that all of the relevant witnesses will be called and all of the relevant evidence will be placed before the court, whether they remain silent or not. In addition, there's an old rule of court that if the defence does not give evidence, then the defence gets the tactical advantage of summing up the case last. But if the defence does give evidence, then the defendant has to sum up first, leaving the prosecution to rebut that defence and giving the prosecutor the last word. So, again, it would be profoundly unfair if the prosecutor could drive the defence to give evidence simply by refusing to place all the evidence before the court themselves. Now, based on everything I've said in this video, it really shouldn't come as a surprise to learn that prosecutors are not allowed to maintain the prosecution if it becomes clear to them that there is no longer a reasonable prospect of success. This can happen before trial or even during trial. If a witness gives different evidence to what the prosecutor is expecting, or if they do not stand up well to cross-examination, and the prosecutor realises there is no longer any realistic chance of a conviction, they have to withdraw the charges and end the trial. Finally, we come to sentence. So if there's been a guilty plea, or alternatively, if there's been a trial and the defendant has been convicted, the role of the prosecutor is to assist the judge to identify a just sentence. It's not the prosecutor's role to aim for the maximum sentence. Solicitor's Conduct Rule 29.12 says, in part, a prosecutor must inform the court of any relevant authority or legislation bearing on the appropriate sentence, must assist the court to avoid appellable error on the issue of sentence, may submit that a custodial or non-custodial sentence is appropriate, and may inform the court of an appropriate range of severity of penalty, including a period of imprisonment, by reference to relevant decisions. Barrister's Rule 93 is in similar terms. In your career, you'll find that prosecutors vary as much as do people in any profession. Some are excellent and fair and professional. Others, particularly some police prosecutors, have a personal chip on their shoulder and they see defence lawyers as the enemy. But for the most part, these are legal colleagues doing a really tough job and complying with a bunch of extra ethical rules. That brings us to the end of the monster week 11. This week has been all about ethics during advocacy. We've learned about the need for formality in the court, the need not to try to pretend like you're over familiar with the court. We've learned that practitioners are required to exercise forensic independence and to ensure that they only make proper use of the court's processes. We've learned a bunch of rules about witnesses and how you can ethically deal with them and prepare them. And finally, we've learned about additional rules that bind prosecutors. Next week is the final week of substantive material for the course. We've now learned all the ethical rules we're going to cover. Next week is all about consequences, professional misconduct, unsatisfactory professional conduct, and the consequences of each of them. 1 week to go. See you next week.